Hello everyone, welcome back. We've got another Supreme Court gun decision today. This one is the Rahimi one, and this one is with regards to restraining orders and can people be disarmed, with a restraining order. Okay, so some background on this case. First of all, the first thing I'm going to tell you guys is you should go over to Mark Smith's channel, right? It's called the Four Boxes Diner, and that's the guy that you should listen to. Okay, that guy is a constitutional scholar. That's the guy where I get all my, like Supreme Court news from. I listen to other people as well, but that guy is the expert. Okay, so what I want to do is I'm basically going to give you a summary. Okay, in case you just don't have time to go over there or whatever. But I'm going to tell you guys right now, that guy is the expert, okay? He talks before, like, the Federalist Society. He writes stuff that there's a good chance that even Supreme Court justices read, okay? So, this Rahimi case, right, where essentially was handpicked by Biden's Attorney General, Merrick Garland, to put in front of the Supreme Court, right, because he wanted to put the so-called conservative justices in a very uncomfortable position where he was hoping to get out of this case is that they would like overturn the Bruen decision or start picking away at it. Okay, so let's talk about Rahimi for a second. This guy apparently has done bad things. He's admitted to doing bad things. So there's a restraining order that's against him. And he fights it through the court systems. Ultimately, he wins, and they say that, hey, you can't disarm somebody with a restraining order. And the way that I guess the appeals court got to that decision was that, hey, looking at the NYSERPA versus Bruen decision, we're going strictly based on text, history, and tradition. And what they basically said in the Rahimi case was, hey, if you go back to the founding era, there was no such thing as restraining orders and disarming people as a result of a restraining order. Okay, so that's what they used to say at the appeals court level that disarming somebody with a restraining order is unconstitutional. So Merrick Garland's like, haha, I got them now, because he's got here a guy that's most Republicans and Democrats. This is the kind of guy that they want to disarm, okay? Now, that's not me, that's them, okay? My personal feeling is if you're safe enough to be on the street, you're safe enough to have a gun. If somebody's a really bad person, prove it. Get him convicted, and then we can talk about, whether he's going to be locked up or disarmed or whatever. But my general thing is if you're safe enough to be on the street, you're safe enough to have a gun. However, that's not how most Republicans, Democrats, judges think. Okay, so soccer moms, right, and a huge chunk of the voters are soccer moms. So this guy Rahimi is the kind of person that scares the shit out of soccer moms. Okay, this is the kind of person that my wife does not want to have a gun. So that's the reason why Merrick Garland picked this specific case to run before the Supreme Court. So, appeals court says, hey, you can't disarm somebody because there's no text, history, and tradition of disarming people with restraining orders. And Merrick Garland's like, we got them now, because now we know that they're not going to want to allow this person, Rahimi, to have guns, which means that they're going to have to go back and unravel the Bruen methodology of text, history, and tradition. They're going to have to come up with some way of taking this guy's guns away, which means that they're going to have to start carving out exceptions and, basically screwing up a very simple concept of text, history, and tradition. Okay? So what the Supreme Court did is and this is the part where we actually win. They kept the Bruen decision intact. Okay. So Garland lost. Okay, what they did is they went and they dug up these laws from the founding era called surety laws, how you pronounce it, and basically they said, hey, there is history in place of disarming physically dangerous people. Okay, so they may have stretched it. Um, in fact, I'm pretty sure, I know that they stretched it, but the point is that they did not have to go and take apart the Bruen methodology. So text, history, and tradition is still the law of the land, and even the conservative, not even the liberal justices, admitted it at some point in the decision. Okay, they admitted that the Bruen decision of text, history, and tradition still remains the law of the land. So to that respect, Garland failed. Okay, he was not able to break apart break down or break apart the Bruen methodology, which was his whole goal. Okay, that was the goal. Okay, so a couple of things. Let's go through here in some details. So the Rahimi case was 8-1 against us, right? Clarence Thomas is the only person that basically said that, hey, restraining orders are like wholesale, like disarming somebody on a restraining order is wholesale unconstitutional. Clarence Thomas, my hero, is the only guy that was willing to say that. But yeah, all other 8 justices basically said that you can disarm somebody with a restraining order. However, one of the things that came up, right, in this decision is that you could do it if they are a physical threat. Okay, so this is important because they state that this person has to be a physical threat, and this is important because in lots of places, what will happen is if you have, let's say, like a divorce case, the attorneys, especially the attorney for the woman, will like automatically request a restraining order, even if there's no history of violence or anything like that. So there has to be a physical threat. So this is something that we now have in writing. Okay, they have to prove. They'll have to prove that there is actually a physical threat and that it is temporary. Okay. So this temporary is something that this temporary part is something that we can come back later to, and again, use in different ways in different court cases. Okay, so like I said earlier, the Bruen methodology is preserved. Okay, so this is the most important thing that came out of this case, and they actually reaffirmed it. Okay, so it's like now you've got, if you go all the way back to the Heller decision, you've got like almost 4 cases up until this point that mention text, history, and tradition. So this is another case that's kind of driving another nail. It has to be text, history, and tradition, and they found a way to disarm this person that apparently had even admitted to doing bad things, violent things. So they found a way to disarm him using these suity laws that go back to the founding era, which which they were able to preserve the Bruen methodology of text, history, and tradition. Okay, that's really important. That's why I keep saying that part. Okay, so in red here we got, Attorney General Merrick Garland. He lost. He lost his goal. He may have won the case, but he lost in his goal of destroying the Bruen methodology. Okay, we've got the liberal justices to admit that the Bruen methodology is the law of the land. Okay, and we also got out of this case that they reaffirm that there is no interest balancing. Okay, which is one of the things that a lot of the liberal judges will try to do, is try to say, yeah, you got a right to bear. When they try to say, yes, you have a right to bear arms, but that has to be weighed against the greater good of society. That's complete bullshit. Okay, so this is now the second time that they're laying out there is no interest balancing. Okay, so this case was decided based on historical analysis, right? Not interest balancing. Interest balancing is dead. Okay. Also, really important, something that came out of this case is that Rahimi is part of the people. Okay, because the only word that the Supreme Court has not really addressed in the past is when they say the right of the people to bear arms. The word who are the people? Okay. Now, to us, it seems kind of obvious that the people are we the people, right? The same people that are on the first line of the Constitution, but it's just not something that had been directly addressed by the Supreme Court. Well, they did it in this case. Okay, they defined the word people, and they basically said that Rahimi is part of the people. Okay, so it doesn't matter if he commits crimes. It doesn't matter. The fact is that he is still part of the people. And what happens is once he's part of the people, right? Despite the fact that maybe he's committed crimes, what that does is it shifts the burden of proof to the government. Okay, all of a sudden it invokes the Second Amendment, because what they were trying to do in the other cases, they were trying to say is because he's a bad person, because he's not a responsible person, he's not part of the people, okay, that the Second Amendment covers. And what happened is, in this case, they said it doesn't matter if he's responsible or not responsible, he is still part of the people, which now shifts the burden to the government, and the government now has to do the work of proving that this person needs to be disarmed, rather than saying that he's not part of the people, and Rahimi would have been the one having with the burden of proof to now show that the Second Amendment applies to him. Okay, so because he is part of the people, okay, the place that we are starting off with here is that the Second Amendment applies to him, and the government has the burden of proof. Has the burden of proof of trying to prove of why the Second Amendment should be taken away from this person. So that's a much more difficult task for the government. Okay? So that's an important thing that came out of this case. Okay, so the responsible citizen requirement is too vague. Okay, which is really important, because in a lot of these states where people are trying to get, let's say, like permits, where they're required to get permission to buy guns or carry guns, they've got this responsible citizen requirement, which in this case the court said that the finding said that it's too vague. Okay, so there's either a judicial finding or there's not a judicial finding. Okay, there's no like, we like this person or we don't like this person. Okay, there's it has to be adjudicated in the court if this person should not have a Second Amendment right. Okay, so unless there's a judicial finding that this person should not have gun rights, all citizens have the right to bear arms. Okay. Now, the other interesting thing that came out of this is with regards to red flags. This case leaves that open. Okay, it's probably going to come up probably next year in a different case, but in this case, it was left open, and the reason is because Rahimi didn't keep his mouth shut. Okay, and this is something really important that I've talked about in other videos. Don't talk to the police. Okay, because what happened is, because this guy started blabbing, okay, and what he did is he agreed, admitted, and conceded. Okay, he actually agreed to the restraining order. Okay, so because of all of that, he basically opened up the door to, yes, they could red flag him because he agreed to it. Okay, so really important. Keep your mouth shut. Don't talk to the police. Don't agree to anything. Don't concede to anything. Get a lawyer. It's going to be cheaper in the long run. Okay. I've talked about this before. I have a prepaid legal service that I use. It's called US Lawshield. You know what? I wasn't even prepared for this. Let me quickly go get a pamphlet for you guys. All right. So as I was saying, so many videos on this. Do not talk to the police. Let your lawyer do the talking for you. The one I use is US Lawshield. The reason I use them is because they're cheap. They're only $11 a month. Okay, and it's a good buffer between you and the police. And then with this promo code here, Pocono Shooting, you get either 1 month off, either 1 month free, 2 months free, or they take $20 off. Right? You gotta sign up through the website, uslawshield.com. Okay, and then use this promo code Pocono Shooting Pocono shooting, and you will get, like I said, either 1 month, 2 months, or $20 off, depending on your state. Okay. So, as I was saying, this Rahimi case, it could have been a lot worse for us. It could have been a lot better. Okay, we could have had, 8 Clarence Thomases or 9 Clarence Thomases on the court, but we don't. So it could have been a lot worse. Okay, the important thing here is that the Bruen decision, the Bruen methodology has been preserved. In order to basically disarm you or infringe upon your gun rights, they have to go through this whole test of tax history and tradition. Okay, so drop some comments below, and like I said, you should all be subscribed to Mark Smith. Right, the channel is the 4 Boxers Diner. Okay, that's because there was a whole bunch of videos that were coming out and a whole bunch of news. I was seeing like all these links this morning in my inbox, and I didn't even want to look at anything until I first heard what Mark Smith had to say. I mean, I'll go back and listen to all the other stuff as well, right, and continue to do some research on this. But I know this guy really knows his stuff, so I wanted to start off with like the facts, right, and then see how this person stretches it and that person stretches it. Because what's going to happen is all the liberal media, they're going to try and twist this into a victory, which it kind of is for them, but it's not a great victory for them, because what they were really trying to do was basically chip away at the Bruen methodology. Okay, so drop some comments. Let me know what you guys think. Talk to you all soon.